All right, we'll call the next case International GOL versus Brevard County. Good afternoon.
Good afternoon. May it please the court. My name is Josh Brown. I'm with the law firm of Peterson and Myers. I represent the appellant, International Golf Maintenance, Inc. The issue raised in this case is one discrete issue. It is whether there's a judgment lien that attaches to the appellant's to the property that's involved in this case. But in answering that discrete issue, the court is faced with and will need to answer a broader issue, which is when there is a conflict between state law and local law, which law controls? Whenever on a specific area of law there is a statutory answer to a question, and then a local body, whether it's a municipality or a county through an ordinance or a plan unit development, then addresses or abrogates something in that statute, is that permitted? Or is that decision trumped by the state statutory guidance on a specific issue? I won't rehash all the facts. I just do want to establish a couple of quick relevant facts. My client was a judgment creditor. They obtained a money judgment in Osceola County against a developer that was handling a development in Brevard County.
Counsel, the trial court found that your client was constructively aware of the existence of the requirement that the deeds be held in escrow. What was the basis for that finding or conclusion? The basis for the conclusion, my understanding was, it was a validly enacted plan unit development pursuant to validly enacted code changes that were made in the county. And we don't dispute or make any argument that it wasn't validly enacted or that there wasn't constructive notice of the requirements of the plan unit development or of the ordinance or even the agreements made pursuant to the planned unit development. So our point is, even assuming there is that Did I just hear you say that you concede that your client had constructive notice of it?
Had constructive notice of the planned unit development and the agreements made pursuant to that. That's correct. Okay. Our position would be, even assuming there's constructive notice or inquiry notice or any type of notice like that, the lien still attaches, and that's because we look at the applicable statute, which is Florida Statute 55.10, which is very clear. It says if a party obtains a money judgment against a defendant, and they then go record that with a certified copy of the judgment, recorded in the county public records, it's a lien on property at that point. That's basically the end of the inquiry. It's a very simple statute.
Let me just help me understand just a little bit about the sequencing of things here. The agreements are made as part of the PUD agreement and some amendments to that the developer would build the beach club and something else. I forgot what the other thing was called.
I think it's a racket club, yes, sir.
And that once constructed, at some point, those would then be transferred over to the homeowners association.
That's exactly right.
And when there were some delays in that, it was agreed, if I understand it, that the deeds to the property would be held in escrow, but the obligation to construct continued to exist. Is that right?
That is exactly right, Judge.
And so the PUD agreements, which long predated the judgment that your client holds, required the construction and the conveyance of that property. Is that right?
That's correct.
And is the issue here, is it really come down to the priority you're claiming that your judgment takes priority over their PUD agreements. Is that essentially it? And their position is that the PUD agreements, whether or not your judgment ever, even if you got title, you're still going to be subject to the PUD agreements. Is that their position?
That is correct, and we don't argue with that. If we were making an argument that we were not subject to the use requirements of the PUD, for instance, what this property could be used for once we took title or another party took title, that's a completely different issue. We're not arguing that we or any other judgment creditor isn't on notice of the PUD, isn't subject to all the use restrictions, just as any new purchaser or owner is at the time they take title to property, whether it's validly enacted use restrictions, zoning regulations, PUD.
Would your client be required to construct the property and then convey it?
I don't believe they would be required to construct it. I do believe they would be subject to the use restrictions, meaning it can't be used for anything else. But that's not a reason to make it.
How does the PUD requirement get complied with if your client or whoever owns title isn't ultimately required to convey it to the homeowners association, which is part of the pre-existing PUD agreement?
It would be the county or the association's obligation under the PUD and the agreements to clear title. Whether that's in the form of, my assumption would be, try to negotiate some kind of satisfaction of the lien in order to then engage in the various obligations, the construction requirements.
I don't understand that. If your position is that your client would take the property, assuming a judgment lien was foreclosed and that you bought it out of the foreclosure sale, if your position is that your client must adhere to the requirements of the PUD, and if one of the requirements of the PUD is that you finish the construction and convey the property, I don't understand how you can only take part of that and not all of it. How do you scour out that part that says you've got to give it the property back no matter what happens?
Let me make a distinction I should have made when I was speaking a moment ago. If we were to then foreclose and actually take title, then those obligations apply. That's not where this is at, and there's no obligation that a judgment lien holder go then and foreclose their lien. The fact that they hold a lien, the limited question is, do they hold a valid lien? There's no obligation to then take the next step and foreclose. And sure, if they actually took title, or if anyone else as a third-party bidder at a foreclosure sale took title, sure, they'd be subject to those obligations. But the question here is whether there's a lien, not whether when we take title, if there are various obligations that we would still have notice of and be required to comply with. And I think that's an important distinction to make.
But although they filed this as a deck action instead of a quiet title action, in essence, what they're trying to do is to determine who ultimately is entitled to the property, and you guys were joined in the litigation, and so you had an opportunity to participate. I mean, it seems to me at the end of the day, the bottom line is, as between the PUD requirements and the lien of your judgment, who comes first? And wouldn't that, if they had styled their action as a quiet title suit and claimed specifically, they could sort of do it inferentially, but if they had claimed specifically that the requirements of the PUD are superior to any interest in the property that you claim, and the judge had said, I agree with that, and it's a done deal, you're out of luck, wouldn't we be right where we are today? I mean, I'm not sure that I agree with exactly the form they took, but didn't you really have a chance to litigate all that? And you've conceded, if I understand, that you would have been required to be subject to all the PUD requirements.
That's correct. If ownership were taken of the property, yes, I agree with that. But the fact is, there was a declaratory judgment action that actually didn't even specifically ask for the lien to be cleared. It was brought up for the first time on a motion. But there was no argument that the developer owned the property and that our lien attached to the property. The judge found the lien attached. It was just a matter of a PUD is out there, and so therefore the lien needs to go away because this lien has to be issued out of escrow.
Doesn't your client, as a judgment creditor, I guess, acquire only the interest of the judgment debtor, the developer in this case? No better than what the judgment debtor has. And in this case, the judgment debtor had an obligation not only to construct and convey, but to convey free and clear of all encumbrances. So how do you say that you have the right to encumber the property, but you don't have the corresponding obligation then, if you step into those shoes, to convey clear of all encumbrances.
I agree. If my client were to step into the shoes, at that point it becomes an obligation they're subject to. Just being a
Hold on.
Yes, sir.
If you take if your lien attaches to whatever interest the judgment the judgment debtor has, and if that judgment debtor has already conveyed the property to someone else, then don't you take only the interest that the judgment debtor had, and he's already given it away?
Absolutely, if there's been a valid conveyance at that point. But
there's nothing wrong with the conveyance; it's just not recorded.
As the cases we cite in our brief address, a deed being placed in escrow by itself, without any further action, without delivery, without recordation, does not change title, does not move title from the original owner to a subsequent purchaser. And if you look at what was said at the hearing, it was agreed by the county attorney that title was held by the developer at the time, and it was agreed as part of the judge's ruling. His ruling is rather straightforward in his oral ruling. He says, I don't dispute that that title is held by the developer right now, but I'm saying the plan unit development controls here, and so therefore your lien can't attach to the property. There was not an issue raised or ruled on by the judge where the judge said, oh no, I don't think a valid title existed in the developer at the time that this lien attached anyway.
If they had pursued this as a quiet title action and they just simply said, we have a PUD that requires whatever it requires, you claim a judgment against the property affected by the PUD agreement, whatever claim you have is inferior, we want to wipe you out to recognize the superiority of the PUD. Wouldn't you lose that lawsuit?
I don't believe so, Judge, because that elevates PUDs and zoning ordinances to the level of title issues. And PUD and use restrictions on what property.
They certainly affect the marketability of the property and the use of the property. I mean, aren't those part of the bundle of sticks that we all learned about in law school?
They do affect the use and the marketability, no question, but they don't affect the actual title or the ability to convey title to the property. The fact that subsequent purchaser...
I think we all agreed that the whoever it was that you got your judgment against, I mean, they could have conveyed title to you. Now it would have breached the PUD agreement. And you conceded that you would have taken it subject to the PUD agreement. So again, it seems like we keep coming back, and I'm not sure how any of that changes any of the result here. If you would have taken subject to the PUD agreement and their conveyance of it, even if they had conveyed it to you.
The fact is, I understand the practical result, and I understand why that's a concern for the court. The fact is, though, at this point, the fact that that might be the practical effect of the ruling, if this lien were to stay, does not mean that this court should agree with the trial court and declare that there is no lien. If the lien stays on, the county or the association would need to deal with that lien, potentially satisfy that lien. Who knows what could happen in the future? The PUD could be changed or modified at some point. Liens last by statute 10 years and then another 10 years if they're re-recorded. Nobody knows what happens. That lien could sit there on that property for 10 years. The property could be something, the use could be changed, the ordinance could be changed, a lot of things could be happened. The fact that right now there's a limited amount or number of remedies for my client if they proceed with their lien does not mean that as a matter of law their lien should not exist under the statute simply because the county passed a plan unit development that says no liens can attach to this property, because essentially that's what the ruling is. The county has made the determination that this particular piece of property, no liens can attach to it. And they can't do that. Now, can they tell the developer, you can't go mortgage the property, you can't do this, you can't use it a certain way? Absolutely. But can they say, and can they tell any potential judgment creditors out there, no lien can ever attach to a particular piece of property? When a statute says, if you record a certified copy of your judgment, it attaches to that piece of property. It doesn't say it attaches to that piece of property, but not if you have a plan unit development, or not if there's an ordinance, or not if you know about an ordinance that's out there. There's no exception like that. The case we cite in our brief, Sharp versus Calabrese, talks about that, where there was a judgment creditor attempting to move on its judgment lien, and they challenged it, the new purchasers challenged it, and tried to look into the facts behind the judgment, or said the judgment had been waived, or other problems were with the judgment. The court said, listen, you've got a judgment lien. It
attaches, and unless a very specific set of circumstances apply, which are it's been satisfied, or some specific operation of law applies to mean that lien is no longer in effect. For instance, there's a prior mortgage, something that actually affects title that can foreclose out the lien. And in that situation, sure, that would eliminate the lien, but a municipal or a county ordinance, plan unit development, is not one of those reasons authorized by law that is cited by Calabrese and referring to Florida Statutes 55.10. On the presumption issue, we'd address it in detail in the brief, but I would very briefly like to refer to the Scurlock case, which dealt with the issue of state statutes that conflict with local law. But I see my time is coming to an end, and I will stop. Thank you.
Thank you. Whoops.
Uh-oh.
Wait just 1 second here. All right.
Good afternoon. May it please the court, my name is Christine Lepore. I'm an assistant county attorney for BREVARD. And I've appreciated the comments from the panel, especially the comment that Judge Perkins made regarding the liens application to the debtors and the debtor's interest in the property, because that's what I think that the appellant is not looking very closely at in this case.
Help me understand. The PUD agreement says, you can't put any liens on the property. But at the same time, it says the developer is obligated to construct whatever they were supposed to construct.
Certainly.
So let's assume they're constructing away, they don't pay the contractor, and the contractor puts a construction lien on the property. Is the contractor out of luck completely because of the existence of the PUD agreement? They have no remedy at all?
They don't have a remedy with that particular property, and the reason why is in the PUD addenda, and particularly the second PUD addenda, that agreement was between the county, the developer, and the ACSA. And that agreement, in that agreement, the beneficial interest in the property conveyed to the ACSA, the Homeowners Association, through the common law doctrine of equitable conversion. That agreement gave the right, beneficial interest right to the property to the ACSA. The developer had no, by the terms of that agreement, had no right to otherwise encumber that property, sell that property, mortgage that property, produce income from that property. And as IGM agreed, they were on constructive notice of that agreement. Granted, it's unrecorded, but it was in the public record and under the recording statute, and also enacted through a public hearing process. So by that transition of beneficial interest from the vendor to the vendee, although...
If someone was to examine title to the property, and so I'm thinking about buying the piece of property that's involved, and I go down and have a title search done, how is a potential buyer going to find out about the existence of the PUD agreement or the claims of the party that the county purports to have?
Well, two ways. One, backing up, not so much in regard to the title report, but in regard to zoning, which is publicly enacted. All property owners are on constructive notice of the zoning requirements, and they have a duty of inquiry to investigate what those restrictions may be on that piece of property. In this particular case, there was reference in the deed into the developer that this property was subject to a PUD. And this court and the Florida Supreme Court has repeatedly held that information within recorded documents that would reasonably lead to the discovery of unrecorded third-party beneficial interest is constructive notice, not only to judgment creditors, but subsequent purchasers. So they are on notice, they're on a duty of inquiry to investigate that information, and in this case, that information was available in the public record through the deed into the developer.
So a contractor, before working on that property, should probably, to protect him or herself, should probably require a bond to be posted for it, a construction bond.
Yes, that would be one way for the contractor to protect themselves in that instance. The 4th District Court of Appeals has dealt with the issue of PUD requirements on subsequent purchasers, and that's the Palm Beach Polo versus Wellington case that's cited in the brief. A subsequent purchaser of property in a PUD wanted to avoid the conservation requirements and the conservation management requirements that were imposed in perpetuity by the PUD. And that developer and subsequent owner argued that they didn't have notice because the PUD wasn't recorded in the public records under the Recording Act. And the 4th DCA rejected that argument, indicating that zoning does not need to be recorded, including PUD zoning that imposes additional restrictions on property that you might not normally find in a regular zoning classification. And as in this case, in the Palm Beach Polo case, the PUD was part of the deeds that were available through the record and through the title work to that particular owner. And that case was denied review by the Florida Supreme Court. So it's not so much that the county or the lower court denied that IGM has a lien, period. There was a distinction made that IGM has a lien against the developer and the developer's interest in that property. It just so happened that through the PUD addenda, the developer's interest transferred in the beach club property to the ACSA at the time those addenda were enacted. So the fact that there were deeds in escrow that had not been delivered as of the date that IGM recorded its judgment lien against the developer is of no consequence. It's irrelevant to the question of what interest did the developer actually own in that property at the time the lien was recorded.
So the judgment creditor wound up having a lien against any other property that the developer might own,
That's
just
correct.
not the beach club because it had previously been conveyed.
That's correct. And IGM has admitted that they had constructive knowledge of that previous agreement to convey that property free and clear of any liens. So in conclusion, the circuit court order is consistent with Florida law. IGM is not entitled to protections of the Recording Act. It admittedly had constructive knowledge of the PUD addenda. The PUD addenda constitute a prior agreement to convey property free and clear as of a certain date. That date has come and gone. And the trial court correctly released that deed to the ACSA free and clear of IGM's lien and any other liens.
Is it now recorded?
It is. And with that, I respectfully request that you deny the appeal.
Thank you. You've got a little over 5 minutes remaining.
Thank you. Very briefly, the statement was just made to the effect that the developer's interests transferred at the time the PUD addenda were signed. Well, that's not the case. If they wanted to transfer that interest and make sure they avoided the possibility of any lien, there was something very simple that could have been done. The deed could have just been delivered and recorded at that point. Instead, the choice was made, for whatever reason, to place it into escrow and not to deliver it or record it. So it's not true that the interest was conveyed at that time. It was still the owner. The trial court found, after hearing the argument and reviewing this motion, that the interest had not conveyed at that time, at the time that the lien was recorded. It's just a matter of whether the PUD controls over the lien interest of my client. And if we were to extend out this ruling, building on the question about the construction liens, how far can a county go in determining that no liens can attach to privately held property? This is property that was still owned by a private entity, and but for an ordinance and a PUD and an addenda pursuant to the PUD, this lien attaches. How far out can it go? Construction liens, other type of liens that are non-voluntary type of liens that are imposed because money is owed or because someone's not paid, and that are enacted or recorded pursuant to statute. State law provides these lien rights. The county then, by passing this particular piece of local legislation, then
takes away that right. In our case, a judgment lien, or in another case, a construction lien. And then finally, and one of the cases was cited by counsel for the appellee in the argument, the answer brief really does consist of a series of cases that deal with cases involving facts where PUDs had been passed, new purchasers stepped in and then challenged or tried to avoid the various requirements of the PUD or the local ordinances. We are not making that argument here, that the use requirements do not apply. We are making the argument that a state statutory lien still applies in spite of a conflicting local ordinance or local plan unit development. And that's why we would ask that the decision of the trial court be reversed.
Thank you very much. Thank you both, and that will conclude our session for this afternoon, and we'll be in recess.